All right, good afternoon, everyone. Thank you for joining today's virtual Lunch and Learn. My name is Sean Momin. I'm the chair of the ADR section for the State Bar of Georgia. And on behalf of the section, on behalf of the executive committee, I want to welcome you all to our Lunch and Learn today. The topic is maximizing ADR opportunities, hot tips from the bench. I'm quite excited about this panel and this topic today, and of our esteemed panelists. I do want to turn it over to or introduce our moderator today, Judge Yael Tucson. She brings more than 35 years of judicial service throughout Georgia to her practice at JAMS. During her time on the Superior Court, Judge Tucson served 2 successful terms as Chief Judge, and she played an active role in the design and launch of the Family Division, which implemented a case management system that featured mediations and judicially hosted settlement conferences, where she also served for over a decade. Her diverse career and extensive legal and community service has garnered her reputation for building consensus during disputes and forging partnerships among the legal, government, and nonprofit communities. She is frequently asked to moderate and present to various audiences, including academic and legal practitioners. Before Judge Tucson was appointed to the bench, she practiced in civil litigation and various areas, including intellectual property, unfair competition, franchise law, family law, and other general business matters. She is the immediate past chair of the Atlanta Bar Association's dispute resolution section. She's a current board member of our section and executive committee member of our section. She also serves on JAMS's foundation board of directors and is the incoming chair, of the GLISI board of directors. Judge Tucson, thank you so much for putting together this wonderful presentation, and I will turn it over to you to take it from here. Thank you.
Thank you, Sean. I am delighted to be here with my colleagues, and we are here to try to share some of our combined experiences and knowledge based on having served on various benches here and outside of Georgia. And we have all made a decision at this point in our careers to use our experience as trial and appellate court judges to help resolve disputes in the private sector. So I'm excited to have you hear from my colleagues. Before we get too far into the discussion, I do want to give each of them an opportunity to introduce themselves to our audience. And I do want to share that we're happy to do our best to answer any questions. You can just put those in the chat, and our section chair will help me to make sure that your questions get answered during the hour that we have together. So first, I would love to introduce to you the Honorable Beverly Martin. And I'm going to ask Judge Martin to just, share with you a little bit about her background and her current ADR practice. And we are at different stages of our practice. And so I think that'll also make this an interesting conversation. Judge Martin.
Good morning. I am in a building in Los Angeles, and there's some music behind me, so I don't know if you all can hear that or not, but I'm delighted to be here, and thank you, Judge Tucson. I'm a longtime admirer. I, of course, spent my time as a judge in federal court, where my experience taught me that federal judges are almost always thrilled to approve settlements because it reduces their caseloads. If the parties agree, it's just one less thing for them to do. So I was going to spend my time this morning talking a little bit about class action settlements, because that Rule 23 of the Federal Rules of Civil Procedure, and I think the Georgia rule as well, requires active involvement of the judge in that, in the settlement of a class action. But I'm going to let you introduce everybody else as well. All right.
Okay, so
Or do
let
you wanna
me,
do that?
as part of you, yes, so I'm gonna have everyone introduce themselves and share a little bit about their background. So we are all aware, I'm sure, of your federal judicial experience on both the trial level as well as the appellate level. But I wanted to just get you to maybe share at this time. I know that as part of your bio, you served as the executive director of the Center on Civil Justice at NYU. And I was just curious as to perhaps how that experience has informed your deciding, to join JAMS and be involved in the private sector.
Well, thank you for that. It did influence my desire to want to be an arbitrator and mediator. The way the centers are set up at NYU Law School is that you have board members that are pretty active participants, most of them NYU graduates, and my board members included several litigation finance folks who had been very successful kind of trying to monetize the dispute resolution process and had done so really successfully. But they talked to me a lot and with candor that I didn't always hear while I was a judge about how in their view the civil justice system was broken. How many enterprises do you enter into, they said, not knowing how long it's going to take, how much it's going to cost, and without a whole lot of predictability about the outcome. And they would say pretty pointedly to me, that they felt like, the solution was not going to come from judges because the situation is pretty good for judges. The schedule is kind of theirs to control, judges to control. And so I got a lot of feedback that I hadn't heard before, but I think it's right that the process ought to be more predictable, and that people shouldn't be have to live with problems that are worrying them in their lives for years and years and years. So there's it really kind of sparked my interest in dispute resolution from this in the private sector.
Okay, well, thank you. Let me move to my colleague, Judge Wendy Shue. We had the pleasure of serving most of our judicial career on, I think, the state court and the Superior Court of Fulton County. And so, Judge Shue, please introduce yourself to our audience and let us know, why are you so interested in mediation, arbitration, dispute resolution?
Well, I served, we served exactly the same time. So 20 years on the Superior Court in Fulton County and 4 years on the state court. Before that, I was a divorce lawyer. And before that, I was a prosecutor in Fulton County for 8 years. And, I don't know that lawyers who don't practice criminal law realize how many of the criminal cases have to be resolved prior to trial. We can try such a small percentage, and so I didn't realize it, but I was learning dispute resolution as a fairly young lawyer, because we would sit in the jury room with a cup of coffee as lawyers came in and out negotiating their cases. And you needed to be a pretty good negotiator. And you needed to be really efficient because cases had to move. And when I was a judge on the Superior Court where we were handling felonies, I always felt like I wanted to mediate those cases. And I would to some extent, and until I was warned that it was actually against the rules, to have the prosecutor and the defense lawyer in my office and just say, you know, how far apart are you? You know, tell me a little bit about the case. And I could knock out a settlement right now, you know. I'm not sure who appreciated that. But so I started early. In my divorce practice, we had very little mediation at that point. But certainly later when I served on the family bench, I feel like we ordered every case to mediation. And a lot of it was on-site mediation where they had a couple of hours. I don't know how they would settle a case in a couple of hours, but sometimes they were successful. So I've understood since COVID, well, I've seen in Fulton County that, and I'm sure this is across the country, that the courts have just they came to a halt for some period of time. And honestly, they've never caught up. And they always prioritized the felony crimes, although they're backed up now too, because you only have so many weeks in the year and it takes a week to try a felony case for the most part. And so the numbers just don't, your civil case is just not going to get to trial for a while. And so mediation can be a great tool and can get a resolution for people early. And generally, if people reach an agreement, they're happier than if a decision is imposed upon them by either the court or a jury.
So it sounds like from hearing both you, Judge Shoup and Judge Martin, that, you know, if a practitioner is, if the suggestion is made that you should try to settle your case or perhaps mediate it before trial, or even ordered, that isn't necessarily a bad thing, that might give them the opportunity to kind of control the schedule and the outcome sooner than later on behalf of their clients.
Well,
Judge
I think lawyers want to try to settle their cases, but I do think that judges have to be careful. I remember as a divorce lawyer going to court for trial with my client. We were ready for trial and we got there and the judge on the Superior Court bench called us into the office, the lawyers, and said, I'm not trying this case. You need to go settle it right now. And so I think we need to be careful that it's a tool, but judges still need to do their jobs.
Agreed. Judge Newman, so happy to have you. You are one of the newer additions to the Atlanta panel of JAMS. So we are delighted. Your career was not in Georgia. So I want you to share with our practitioners who may venture into your state why you're here and kind of a brief introduction, if you will.
Yeah, well, the great thing about mediation and arbitration is I can venture into all states since typically there's no local bar requirement for mediation or arbitration. I wrapped up 24 years on the trial bench last year, and as a full-time state court judge in South Carolina. And I'm currently designated as an active retired judge, which means that I continue to preside on a reduced basis as a judge, while at the same time having an active arbitration and mediation practice. I attended law school in Cleveland, practiced law there for 6 years, and as a defense attorney. Returned to South Carolina, and after a brief stint as a defense attorney, I became a prosecutor. Prosecuted for 16 years, then was appointed as a state court judge, where I served for 24 years. So I've had the benefit of seeking and resolving cases on practically all levels. I certainly enjoy the challenge now of helping resolve matters through mediations, arbitrations, or what have you.
Okay, well, let's jump right in. We obviously have had an opportunity to talk a little bit as a panel about what we wanted to share. And one of the things that I thought would be interesting to the audience would be focusing on crafting the mediation agreements. So this is, I guess, the assumption is either that you've had a successful mediation and now it's time to reduce it to writing in a way that will, assuming that the case has been filed, approved by the assigned judge, or you're coming to the mediation perhaps with a draft of an agreement. And so depending on the subject matter, there may be a variety in how the judge responds to actually receiving the settlement agreement, how closely it's read, et cetera. But I wanted to start with Judge Martin because we had kind of discussed this, I think, in the context of class actions and agreements. So take it away.
All right. Well, like I said, the federal rules of civil procedure require really active involvement from the district judge, and then allows appeal rights to objectors to a class action settlement, no matter how small a minority they are. So I mean, you're headed for a lot of process when you're trying to settle a class action suit. I read an article by some defense lawyers that were recommending to settle it with the named plaintiffs before the class is certified, because at that point, it doesn't require the judge to be involved. But there's some judges that insist on being involved even at that stage before the class is certified. They want to be sure they understand how the resolution of the matter with the named plaintiffs could impact a future class over the same fact scenario. So there's a lot to think about as you're trying to resolve, see if you can resolve a class-wide dispute. For the practitioners, before the judge ever sees it, I mean, depending on the number of class members there are, you may need a class administrator. Of course, you've got to figure out how the settlement's going to be funded. You can do what type of common interest, a common fund or a claims made fund. And you have got to be sure you meet the requirements for notice about all the agreements that you're making, where there's more than one defendant involved. It can be like a criminal case. I mean, you have to be sure you have a common interest agreement so that you can share confidential information with one another. You want to make sure you're protected in that way. One thing that happened while I was still at the 11th Circuit, the 11th Circuit no longer allows, or I'm not current. I think this is still the law in the 11th Circuit that doesn't allow any payment for the time spent by the named plaintiffs. There are some jurisdictions, there's some other jurisdictions where that's true. There's some jurisdictions where you can still make a payment for services to the named plaintiffs. So then if you make it through all those hurdles, you present it to the district court and federal court. And as I've said, Rule 23 requires the district judge's approval. So there will be a hearing, and oftentimes there's a preliminary approval after the hearing. And then, the ultimate approval of the settlement. The judge is charged with being sure that the settlement is fair, reasonable, and adequate for all class members. He or she has to inquire into whether the class representatives did an adequate job of representing the other class members, whether class counsel did an adequate job, were the negotiations to settle the case arm's length. And since I'm here on behalf of one thing I know district courts look at was, if there was a reputable or admired mediator like my colleagues on this call that was involved in working out the settlement, that gives the district court some level of comfort that there was an arm's length negotiation. Always when you make these presentations to sell a settlement to a district judge, you've got to talk about the weaknesses in your case, which is something we're not used to doing in court. But we got the judge. I think Rule 23 expressly requires the judge to consider the cost, risk, and delay that could be occasioned by trial and an appeal. And then, the proposed method of distribution, and that sometimes, requires a settlement administrator, which is expensive. And then most judges require at the settlement stage another opportunity for the class members to opt out. So it's a process. It's a long process. And then if you make it through all that, then Rule 23 still allows any class member to object to the settlement on behalf of himself, herself, a subset of the class members, or the class entirely. And that's who we would see in the Court of Appeals, because once the district court had agreed to settle the case, the objectors have a right to challenge the settlement and appeal. So that's really where we would see them. And I looked at a couple of things. Like there's a colleague, he was a friend of mine because I was on a committee with him, Brooks Smith from the Third Circuit, wrote an article about these objectors, and the criticisms of that they're very good objectors and very capable objectors, and sometimes very necessary objectors. But one of the terms that this article that Brooks Smith and his colleague wrote referred to them sometimes as exploiters of the system. And the way the rules are written, an objector can come in without really knowing how the settlement was arrived at. So one thing that I know practitioners are doing now, and asking district judges to do it as well. There was a Fourth Circuit case where precisely this has happened. The district court had approved a settlement. There was an objector, and the district judge overruled the objection, approved the settlement. It was I mean, I don't know anything about this except for what I read in the case. That it was a $40 million settlement over insurance policies. And this was a 2022 opinion from the Fourth Circuit. And the minimum recovery for a class member was $100 in, premium refunds. That was the minimum. There were people that got more than that. But when it went to the Fourth Circuit, the Fourth Circuit went through the reasonableness of the settlement, and one of the things that they looked at was that the district court had allowed discovery by the objector, so that it gave both sides more ammunition to defend their positions on appeal. But the fact that the objector had been allowed discovery to know what had happened in the settlement agreement was one of the factors that led the Fourth Circuit to affirm the district judge and approve the settlement.
Thank you, Judge Martin. Do we have any questions, Sean, about class action settlements? Just wanted to pause if we do. If not, I'm going to move to Judge Newman and Judge Shub, who both have considerable experience with business court litigation, and that's what I want to focus on at the moment. Judge Newman, I know that you were past president of the American College of Business Court Judges, and Judge Shub was one of the formation judges for the business court for Fulton County. And so based on your experience in presiding over business litigation, I wanted to give you an opportunity, if you wanted to speak at all about any kind of your review of settlement agreements in that area, whether or not there were any trends of loose ends that, made the settlement difficult to approve, that sort of thing. Let me start with Judge Newman.
Yes, well, I did serve as the president of the American College of Business Court Judges. I had an opportunity to develop a kind of close relationship with Steve Schuster, Judge Steve Schuster from Cobb County, I believe, who
Yes.
also was a predecessor of mine at one point. Well, if I can comment about the class actions, I've dealt with a lot of those as well, involving certifying, decertifying, approving, and approving compensation. So in my neck of the woods, people who serve as class representatives can be compensated, but and I mentioned that to contrast with the great movement, it appears, toward mass arbitration, which has taken some of the steam out of class action litigation based on what's written into those types of contracts or clauses or agreements. My role as far as hosting settlement conferences, we do not have a defined statutory role as far as conducting settlement conferences. They come in the context of what is the status of the case and preparing a case for trial as opposed to preparing it for settlement, and also having a pretrial conference when the matter is ready for trial. Of course, the judge has, well, in some places, there's mandatory mediation, which the court oversees and which has to be enforced. And in many instances, before the case can come to trial, there must be mediation. But based on my experience with the dealing with business courts over the years, case management is an essential quality that one must have, in which a judge who's presiding must be one who can manage litigation and to create a case management order to put the case on track, to get it ready to be mediated and tried if not settled. And that same applies to matters through that I now deal with through JAMS, that is either through mediation or, in more instances, arbitration, which is another form of case management, moving the case through the ranks, getting it ready to be resolved. There's always difference between the two. A judicial hosted case management versus pretrial conferences. The goal is the same in each, but the pretrial conference is what I'm most familiar with as far as managing a case.
Okay, thank you, Judge Newman. Judge Shu, in terms of your business court experience, can you speak to any issues that you recall arising in connection with the actual proposed settlement agreement that's presented, at the end or at the beginning, whenever it occurs in connection with a business case filing? That's what I'm asking you about at this time.
Well, I would say that judges are always happy to see a lawyer who is presenting a settlement agreement. And I guess public policy favors settlement, and settlement means a case is off your docket. And so a business case or other kind of case, I'm generally happy to see a settlement agreement. And I can't tell you that I've ever not approved a settlement agreement unless there was some sort of objection that accompanied the agreement. Because ordinarily, an agreement comes in and both sides have signed and the lawyers have signed, and I don't know enough about the case, the details to know if there's a problem with the agreement. I would tell you in family court, it's a little bit different because I would generally scrutinize what the child support looked like and what the visitation schedule looked like, because sometimes, a parent will negotiate away a child's right to child support for some reason that I don't know or understand, or a visitation schedule just looks unworkable or bad for a child. But ordinarily in a business case, certainly you don't have those kind of issues, and I'm not going to know enough details as the trial judge to know that there's something wrong with this agreement. Somebody's going to have to tell me that. So I'm going to happily sign it, and then if there's an issue, I'll hear about it and deal with it.
Well, I have similar, I guess, recollection from family division days, when every once in a while there would be an agreement and everybody is thrilled that they've reached an agreement. And then when you look at it, there's some deeply rooted public policy, not in the best interests of the child, kind of deals that have been reached, maybe at the end of the day, maybe under duress, who knows, when I would have to send it back. But generally, I think all judges are happy to have a case resolved, and certainly want to support the effort made to reach a resolution. There was some mention about the judicially hosted settlement conferences, and I know that there is currently a good bit of discussion and maybe even some, I don't know if it's legislation or if it's coming from the Supreme Court, quite frankly, but in terms of, I guess, creating a certification for senior judges to conduct judicially hosted settlement conferences in Georgia. Previously, senior judges in different jurisdictions have had the opportunity to be involved and have probably approached resolving cases differently. Maybe, as Judge Newman suggested, it might be more of a case evaluation, some suggestions that might be made similar to a pretrial conference that has evolved into trying to help the folks settle. But in many instances, a senior judge may be asked to try to resolve a case that has been assigned to an active judge. And that's been more of my experience, and has been an interesting journey, because it seems that practitioners come prepared for those differently. I think if they're prepared as if it's going to be a mediation in good faith, you can be successful. But if they've been ordered to this experience and they're still protesting, then usually those are not as successful. Let me ask all of you or those that wish to respond. I'm shifting now to the topic of motions to enforce settlement agreements, as opposed to everyone agrees there's an agreement and we just need the blessing of the court to get the case resolved. Do you have any tips for the filing and actually the arguing of successful motions to enforce?
Well, I would say that if you reached an agreement and for some reason can't get the other party to sign, or it's falling apart and you feel the need to move to enforce your agreement, I think you need to make sure that you have your agreement, your evidence, affidavits if necessary, and you can file it. Certainly in Fulton County, you need to ask for a hearing because that needs to be heard by the court. And I think most courts are pretty open to enforcing a settlement agreement. There are only a few reasons why you wouldn't enforce a settlement agreement, and certainly, did it cover every issue? Was something material left out? That's one that pops up occasionally. Sometimes the complaint is that the attorney didn't have the authority to settle, and I see that when maybe it's an email agreement and the attorney has agreed by email, and that's obviously not the best practice, but it's certainly enforceable if they had authority. Sometimes the client will complain that they were coerced, felt pressured by their lawyer, even by the mediator. Sometimes it's just buyer's remorse. People will settle a case and then afterwards really regret that they settled it, or maybe circumstances changed and maybe a stock account has suddenly taken a nosedive. It's not worth today what it was worth 2 weeks ago when I settled the case, and this is just so unfair. And so, there are reasons why people don't want to sign at the end or refuse to participate. Maybe they just can't afford the deal anymore. They've lost money, or sometimes they just are buying delay. And I think that's why courts need to address them quickly, and you need to really push to get a hearing so that it can just be handled, because you just don't want something like that to linger.
Great advice, Judge Shu. Judge Newman, did you want to add anything?
Yeah, sure. Of course, mediation means to resolve matters short of trial. If there is a settlement as a result of the mediation, it certainly must be in writing and comply with court rules and be clearly written. And best practices obviously is to have the parties sign approving the mediation prior to leaving the mediation, so that there is no doubt that there has been an agreement. There are court rules that take over where a party seeks to rescind their agreement, and in most instances, they cannot. In our state, no settlement agreement is binding unless it is in writing or made in open court and made part of a court order. I think Georgia rules are a little more relaxed in giving lawyers authority to bind a client with regard to an agreement under the agency concept, and maybe the client can be held to the agreement based on the lawyer's conduct. Our rules are a little more stringent in that regard, in that the must be signed or agreed to by the parties, including the client, or at least made in open court, so that it's clear that there is, in fact, an agreement. And I think that that's really important, the clarity through which these orders are made at the end of the mediations to comply with the court orders, so that they can be properly enforced by the court.
I would say one issue that sometimes comes up is where a party will complain that they didn't know about an account, or some information was withheld or misrepresented by the other side. So they're in mediation and feel like they were misled. And the first question is always, did you conduct discovery? Because if you didn't ask for this information in discovery, then you're screwed. And and I really hate being involved in mediations where the parties are arguing about some issue, some account, or a witness, maybe an expert witness that no one has deposed. And they're arguing about what this witness might say, and they're each sure of their position, but they haven't deposed the witness, and you're in mediation, and you're just saying, how am I supposed to settle this when you haven't deposed this witness? Like, it would just be nice if you would do your discovery in advance of the mediation. And I think a lot of people feel like early mediation is great, it saves money, but I feel like I just think it's impossible to settle a case early like that when you haven't conducted discovery, and you're taking a big risk because there's information out there that you don't know, and you find out later. I think it's really dangerous.
And that's the strategic decision of when to mediate. When each party has to consider that. Some parties who want the early mediation, they want to try to get it resolved prior to full discovery, because the matter becomes more difficult to resolve after full discovery. But I agree with you. It certainly would seem prudent to me to have discovery done prior to attempting to mediate a claim.
What about I've seen this happen a lot. One party, one attorney usually will agree to put the agreed upon settlement in writing and present it to the other side, for review and signature. And when the other side gets the agreement, then they're like, well, whoa, we didn't agree to all of these extra things that you've put in that have been included under the auspices of legally standard language. What happens then? I mean, do you have any guidance as to the extra stuff and whether or not that is actually a reasonable expansion of the agreement or not? Anyone?
I think you can, you certainly understand why the parties need to sort of fill in the gaps when they go back to their offices and write it up. But when a disagreement develops about some paragraph that one party feels like changes the agreement, if there's a motion to enforce, I think you have to enforce the written agreement that the parties signed without all of the extras. And then they're just going to have to deal with the fact that you've got you might have some gaps, but it certainly can't be a gap about anything important, or you just don't have an agreement.
And that brings up the challenge to the mediator to make certain that the mediation concludes with a well-written agreement that is signed by the parties.
But it's hard to write a well-written agreement when it's 10 o'clock at night and nobody's eating dinner, and
Right.
Everybody, including me, wants
Right.
to go home. And so they're typing it up really fast, and they're hoping to get something, but it's not a fully fleshed out agreement ever. And so you can run into those issues later.
So how about a well-written outline of the agreement? Maybe not, obviously the whole agreement, but whose responsibility is that as the mediator? So I'm now asking you, as mediators, do you view that as being your responsibility to knock out the outline, or do you look to, assuming that they're both attorneys, one of the attorneys to do that?
Definitely the attorneys.
Yeah.
As opposed to yourself?
They're not paying me to write their agreement. No.
I
You
don't
don't
believe
want me
that.
to write your agreement. I mean, because the lawyers have been living with this case for a couple of years, and I've been living with this case for, 2 days. And so they don't want me writing their agreement. They know what needs to be in there. And if both sides are agreeing to the details, I'm satisfied.
And the mediator would not typically be a witness at the enforcement hearing.
Well,
Yeah.
true. I mean, don't we all, we go over all of that at the beginning. And so, and typically, I don't know, what you all do, but not keeping the notes from the mediation for terribly long either. So, you're kind of on your own in this motion to enforce. We do have a couple of questions. So I do want to make sure that we get to the questions. One question is, what rules govern discovery in mediation? Is it the Civil Practice Act, or are there specific rules within the Georgia Office of Dispute Resolution that's specific to mediation?
Well, I don't think you have to conduct any discovery at all to have a mediation. So I don't know of rules that are involved, discovery rules involved in mediation. All I know is if you are presenting information at a mediation and if it's false, then that can be a reason to set aside the agreement.
Judge Martin, there is a question here for you. It's actually a two-part question, so you can answer both or one or whatever you
hope I
wish.
can answer
You're the
either.
judge. What if the judge refuses to certify the class? And part two is, should the judge consider the many mediations in individual cases that will result if there's no certification? In other words, the cost of all those mediations overloads the individual plaintiffs, does it not? Where is the fairness there?
Well, I'm sympathetic to the questions. I spent the last 11 years of my time as a judge trying to negotiate with two other panel members, and I didn't always agree with what they wanted to do, and it's hard to get a judge to do something they don't think they should do. So I'm sorry if you've had that experience where the judges refuse to certify a class. Yeah, and I mean, I think you have a good argument about for certifying the class in terms of talking about the time and expense of all the individual mediation, because those are considerations set out in Rule 23 for federal judges to consider in not only certifying a class, but accepting a settlement. So, I feel your pain, but in terms of how to get a judge to certify a class that they don't want to certify, I wish I knew.
Okay, so I know everyone wants us to share, whatever we find to be best practices, very helpful for successful mediations. I know, speaking for myself, that over the years, I have moved away from any type of opening statements by the parties during mediations. I don't find that helpful at all. I don't know if it has ever been helpful, but what I do find to be extremely helpful are pre-mediation calls and the opportunity that that affords me to learn about the case, to learn about the parties, to find out, what the weaknesses and everything and strengths are, so that I can prepare appropriately as your mediator, and you don't have to spend time during the mediation trying to get me up to speed. Do you likewise value pre-mediation calls? Asking my co-panelists, and assuming yes, how can practitioners best prepare for such calls?
I would say I like calls, but first of all, I like a mediation statement with any additional information they want to give me, because I don't think lawyers necessarily realize that when they've been living with a case for a while and their clients have been living with it for a while, it takes a minute for the mediator to get up to speed. And if you want a mediator to be effective, your mediator needs to have enough information and enough time to digest it. So, I mean, not a statement the day before, but it's nice to get a statement a few days, or a week before, and then have a call to be able to ask questions that maybe aren't answered in the mediation statement. But I would say in preparing your client for a mediation, the first thing to tell them is that this is not litigation. So I think lawyers need to explain to their clients that they're not going to go in as like an advocate who is it's just a different role. You're advocating, but you're also you have on a different hat, so that their expectation is not that their lawyer is going to go in and kick ass, because that's just not going to be an effective mediation. And it helps for lawyers to explain to their clients, obviously, the advantages of settling the case. But most importantly, I think it helps to have talked to your client about what do they want? What do they want to say? What do they think a settlement looks like? Where would they be willing to make a concession? Does the other side have a point of view that somebody neutral might understand? Just try to get your client in a settlement mode as opposed to an adversarial mode. And and it's also very nice for lawyers to tell the mediator, if your client has an issue, I mean, is your client crazy? This would be good to know in advance. Are they super difficult? Do they have some just really touchy subjects that, it'd just be nice not to just step into, because our goal is to bond with them and create some rapport with both sides, so that at the appropriate time you can nudge them. But and I've done this before, where I just irritated somebody early on, just would have been nice to know. Don't talk about that, And
Can't imagine you irritating anyone, Judge Hsu.
I know. I know. You've never seen me do that, have you? So some people like that approach. So yes, it's nice to know, and it's just nice to know if your client's difficult, because if there are ways to handle it. So just tell me, and it's not like the other side's not going to tell me anyway. So you might as well share and come in and be honest. I mean, this is not like you're in court where you're withholding information that's not helpful. This is coming out, and so the more you can share with the mediator, the more they can use it and figure it out and help you. And the more you put in, the more you're going to get out, and the less you put in, then you're not going to settle the case.
Well, thank you, Judge Hsu. Judge Newman, is there a tip or two that you would love to share before we conclude?
Well, there needs to be I think, a neutral location, one in which neither side feels that they're in a dominant position based on the comfort of where the mediation is taking place. I think the mediator should try to exude to the parties that this is an opportunity. We're not in court, but this, in effect, you're having your day in court through this mediation. There must be a willingness and a desire to get the matter resolved through mediation. Where there's court order mediation, then there's no obligation for the parties to settle, and sometimes there's a lack of desire. But I think that if we can have a mediation where all parties desire settlement, then we can get farther along. The mediator needs to be provided all necessary information for the mediator to understand the nature of the litigation that we're trying to get resolved.
I know that sometimes it's difficult in a mediation when the information that has been shared with each side. So this would be whether it's informal or formal discovery, when there are just, lots of different documents being referred to and, you're trying to share it. And I have found that spreadsheets are extremely helpful for me as the mediator, as well as the progression of the mediation, such that if one party or the other has it up on their device, they can potentially even be updating a division of property if it's a family case, or other issues that are on the table with the information that is being shared as the mediation is progressing throughout the day. And that probably requires some extra work. But I think my point is that, again, the extra preparation that goes into starting the mediation, as well as the attorney that is able to, revise agreements and things as you go along, gives you the edge in actually kind of controlling some of the outcome. So I think that is time well spent. Do we have any questions, Sean, that we should address?
I did
think we
not
have
see
a
any
few
questions
minutes.
come my way.
I can't quite hear you.
I did not see any questions that came my
Okay.
way.
Okay, all right. Well, I think we're close to time. We're not quite there yet. So I did want to make sure that we covered everything that we had hoped to cover. And I think, in looking at my notes, that we probably have. So I would just like to maybe go around and give each of the panelists just an opportunity to make some closing remarks about mediation and, why you're a believer in this form of dispute resolution. Judge Martin, did you want to start off maybe?
Well, I enjoyed listening to what you all had to say about it. I'm still making some of the mistakes that you talk about having learned not to make. So I appreciate that. Will that work as my closing argument?
That absolutely works.
Okay.
Thank you. Judge Newman?
Well, it's a wonderful transition from the bench after spending years issuing orders and making demands of the litigants. It's good to play a more neutral role and sit back and try to facilitate. And it takes an expertise to do that. And I try to develop it more and more the more mediations I do.
Well, that's for sure, Judge Newman, and we'll caution you, Judge Martin, as judges, we are used to making the decisions and people doing what we say usually. And so that definitely is part of the transition of taking off the robe and, sitting around the table, is that you're there to facilitate. But it's not your case anymore. And so that does take an adjustment. Judge Shu, I think you're going to have the almost final say before I close this out.
Okay, well, I would just say that I find mediation really hard. And I know people who do it every day or, a couple of days a week. I'm telling you, it is exhausting. Maybe it's hard for me just to be nice to everybody for that long, but it's easy. And people are just different personalities, but I'm happy listening and telling people what to do. But getting them to reach an agreement when they've been at war for a couple of years or longer. Maybe it's a probate case and it's family, or it's whatever it is, it's personal. And people can be extremely angry, and you have to get them to a point where they can give up something that they don't want to give up, and they can accept an agreement that they don't like, because a good agreement is one that both sides loathe. And in order to get them to that point is tough, and I'm exhausted at the end of the day. So I think it's an amazing process when it works, but it takes a lot.
Well, thank you all for joining me on this panel. This is a 1 hour CLE. So yes, there was a question. There should be 1 hour CLE eligible. And I trust that the materials that accompanied your registration will be helpful, and that the process for getting your 1 hour of CLE will be easy peasy to obtain. The 4 of us are affiliated with JAMS, but hopefully what we have shared today across the board will be helpful to practitioners as well as mediators. And we've enjoyed spending the noon hour with you. So thank you.
Ladies and
Thank
gentlemen,
you.
this does conclude today's meeting. Thank you for joining, and have a great afternoon.